the evidence that we have. The evidence that we have is that you knew of it before then because you called to make payment arrangements, and you admitted to that on the record. Laskew versus Amber Esser, 06-01089 GC. Appearance, please. So your name, ma'am?
Amber. Well, it's Amber Allen now, Your Honor.
Okay, today was the date that was scheduled for a motion hearing. You filed a motion to set aside a default judgment from 2018.
I believe it was from 2006, Your Honor.
No, even worse.
Yes, ma'am.
Yes. The court is in receipt of your motion, and I believe it says that Mr. Smith or the plaintiff's representative has filed a objection. That's what I'm looking for here. Okay, I see the plaintiff's reply. Again, this was a physical file, so I just saw this today. It says that the defendant's plaintiff's reply to defendant's objection to motion to renew judgment.
Correct.
What is the basis upon which you believe that your case can be withdrawn from judgment? And I guess, what do you want, proceed from scratch? What are you looking for?
Well, I don't know how it all works, Your Honor. If I could do that, I suppose. Originally, and I believe it was 2006, I was never properly served.
What does that mean?
Nobody had told me about the Mr. Smith has something that says I signed it.
A proof of service.
Yes, ma'am. That wasn't me who signed it. I was gone. I was in the Army. I filed my DD 214 with you guys on my files. We say that we can see that.
Okay, this is not an electronic file, so I don't know how you filed something on my file. Let's see.
Oh, well, I believe Mr. Smith responded to my motion from my file.
Okay, yeah, I have a paper file for a reason, because this is not a physical file.
Okay.
Exhibit A to my reply, Your Honor, is the proof of service by Mike Ramsey of the summons and complaint upon Amber Esser on March 30th of 2006. There is signed acknowledgement of service.
I have a signed proof of service with your name on it.
Yeah, sure. That was my mother's signature, Your Honor. I'm aware. It also says that it's the height between 5'6" and 6 foot and describes a blonde female. And there's also another proof of service in here that doesn't have a signature on it from, I'm not sure, 2000, let's see, 17, that he also said he served me with.
How do you know it's your mother?
Recently, well, my mom just passed away and she had opened a lot of things in my name. I was aware of the vehicle. I was aware of it, but I wasn't aware of the debt, which I think originally there was gap insurance on it. It was in, I don't even know which year, 2006, I guess.
What do you mean you were aware of the debt? What does that mean?
So
Of the vehicle.
I was aware that she
It wasn't your vehicle,
No,
but you were aware she bought a vehicle in your name?
that's correct. Well, I think it happened about a month after I turned 18. Mr. Smith has the paperwork in here from last year. Well, it says Annie Ray Chevrolet, so it was, well, this says January 30th, 2000 and, well, I don't know if that's right. It was shortly after I turned 18. She also opened some credit cards and bank accounts at MSU Federal Credit Union that I just recently had to deal with as well. So
Deal with them how?
I ended up getting them. MSU ended up not making me pay the debt. I don't know what the correct terminology is, but because the signatures didn't match up.
So you're saying this is not your signature on the proof of service, and this is not your signature on the bill of sale?
Yes. So these are from my mom.
No, I'm asking you very specifically. You're saying those are not your signatures?
Yes, correct. But I also tried taking care of this debt with, I had gotten a lawyer last year with, who was talking to Mr. Smith, so I'm not sure. The only reason I had filed the motion is because after I had gotten an attorney and it couldn't get worked out between the attorney and Mr. Smith. Over a couple $100 on a settlement agreement that I had offered several times with Mr. Smith that he denied. I got a letter in the mail from his office, which is the only reason why I filed the motion, because I can't afford, I'm 100% disabled veteran. I can't keep affording to pay $410 for a lawyer every hour. So I just filed it myself, not really knowing all the things, but I did make you a copy of the email thread if you wanted to.
The email thread is about your attempts to resolve the debt?
Yes.
No, I don't need to see that.
Okay.
That's private negotiations about possible settlement.
Sure.
So that's between you two. I'm more concerned with the underlying issue here. Mr. Smith, did you want to respond to her motion?
Sure. We attached as Exhibit A, the proof of service. You see the signature there. You see the signature at Exhibit B, the underlying contract. Signatures are identical. The interesting thing is, Your Honor, this is the first time that this individual has said that's not me. My mom was running around town and she was opening up an accounts in my name. Our file reflects that on May 13th of 2016, after the first renewal, she called, we talked, and she wanted a payment plan. During that phone call, there was no mention of that's not me. I don't know what this is. In fact, her motion today states, I have no prior knowledge of the original judgment. And we had contact with, and we have been chasing this individual now for 20 years. And it's been a run trying to get paid. In 2017, after personal service of a subpoena for a creditor exam on November 1st of 2017, she called and requested a payment plan. The file notes in my file reflect that. At no point in that conversation did she say, I don't know what this is, or my mama's running around town opening up accounts in my name. This is the first time in years of this defendant and I being involved in this case, trying to get this balance paid, that she's ever said, that wasn't me, that was my mom.
Sure. He also does keep saying that he's been talking to me since 2000 and well, he said 16, this says 2017. Also doesn't have my signature on it. When I get called into court, I show up for court. So I'm not sure why he keeps saying he spoke with me.
On the phone?
Correct, allegedly. On the phone. Had to have been, because he didn't see me. I've not ever seen him before.
Well, he said you called and requested a payment plan.
That's what he says. So if I requested a payment plan to something, why wasn't it paid? I mean, I'm just not one that not pay my.
You asking me? I don't know why it wouldn't be paid. I couldn't.
I'm just saying, Your Honor, I pay my bills, so it's not like.
As an example, Your Honor, after the 2017 phone call where she called me and requested a payment plan, she wanted to pay a certain amount of money per month on November 2nd of 2017. I mailed her a letter confirming what we discussed on the phone, told her how to make the payments. And again, no talk of this ain't me, this is my mom.
Okay, and you say you mailed a letter. What address did you mail it to?
The one she gave me at the time was 30 O Avenue, Climax, Michigan, 49034.
And that's the address I have here on the process server for the motion for benchmark. Let's see. All from 2017, 2018.
That payment plan came, what prompted that call, Your Honor, is the court file reflects personal service of a subpoena for a creditor exam on September 24th of 2017. And on the eve of the exam, and this is what happens with this defendant, she called and wanted to avoid it and start a payment plan. In fact, my notes reflect that she told me I'm a disabled vet, but quote, my man can send the money. We keep very specific notes about all contact with defendants, and not once in 2 decades of contact has this person said, this is the first I've heard of it, or my mom was running around open account.
Sure. So regardless of what Mr. Smith is saying, I tried to take care of this obligation that I said that wasn't mine just to get it taken care of. And Mr. Smith keeps telling the lawyer that I had hired, no, sorry, we need this amount. No, sorry, we need this amount. And then he offers a settlement agreement of $5,000. And then 3 days before the settlement agreement expires, we offer to pay it. And he says, nope, sorry, we're withdrawing the the agreement. So, I mean, it's become extremely difficult to even try to get the debt taken care of, although it's not my debt. And I'm sorry, but I'm not sure that I'm allowed to even tell. I don't know. I'm not a lawyer. I'm not sure I was even allowed to tell Mr. Smith. And also just found out about a lot of the things that my mom had done.
No, you didn't just find out about this because you told me that you were aware that she had a car.
I was aware about the car, but I did.
You gave her permission to use your credit.
Well, I didn't give her permission to use my credit.
You were aware you didn't report it reported as theft or fraud.
No.
Not only were you aware you didn't report it as fraud, then I'm assuming you all must have lived together at the time. Is that what was going on?
No, I was in the Army at the time.
Oh, okay. Well, you must have your permanent address must have been the address that you used to get the vehicle, and that was where you were served. That she allegedly is where you're telling me now. She allegedly served or was served in accepted service. So if you want to have the claim that you want the court to believe is valid, then you would have needed to show me where you, sooner than 20 years from later, have come to the court and say, hey, this is fraud. This was not mine.
Sure.
It's not sure. Listen. Okay. And not only did not happen, we now have evidence that you have assumed the risk of the debt. You know that can happen.
I don't know.
A statute of limitation could just about run for something and you accept responsibility for it. So not only do we have signed documents that say that they were you tell me on this record that you knew of the debt, and then you also, I find out on the record that you also not only knew of the debt, but you tried to resolve it and took ownership of the debt with the plaintiff.
Well, I didn't know of the debt until last year, and I took ownership.
That's not the evidence that we have. The evidence that we have is that you knew of it before then because you called to make payment arrangements, and you admitted to that on the record.
I didn't admit to making payment.
You did try to make it. You did try to say you tried to take care of it.
2025. Yeah.
You tried to take care of it. But you called before then.
No, I didn't. That's the thing. I didn't. I found out, as soon as I found out about it, I got a letter in the mail at my house that I own. And in 2025, at some point, I think it was like May, I found out about it and I called Mr. Smith myself.
Oh, so you're saying that the calls that he got the day before the debtor's exam were not from you?
I never went to a debtor's exam.
We know that. That's why there was a warrant or a request for warrant. But we're now saying is that the calls that Mr. Smith's office received on the eve of those debtor's exam were not you.
Yeah, so when I found out about this in 2025, I called.
You said yeah.
So when I found out about
you see my question? The debtor's exam in 2016 or 2017, that the call that Mr. Smith's office received November 2nd, 2017, you're saying that was not you?
No.
And so you are purporting that was your mother?
I don't know who it was.
Oh, just a random person called to clear up the debtor's exam.
Well, I'm
after
not sure,
receiving notice of a debtor's exam.
When I received notice of it, I called Mr. Smith and then got an attorney to take care of it.
So you want me to believe that you never spoke to Mr. Smith prior to 2025?
I called Mr. Smith in 2025 when I found out about it.
You want me to believe that you've never spoken with Mr. Smith prior to 2025?
Do I want you to believe that?
Yes.
Yeah, I mean, that's when I had contacted him, was in 2025.
I'm not asking you if you contacted him in 2025. Did you speak with him ever prior to that?
No.
Okay, so you're saying all these communications that they have documented prior to that were not you, they were your mother.
I don't know who they were. They had to have been my mother.
You're assuming that they were your mother, is what you're saying. You say we're not you.
Correct.
Okay. Well, the issue that I have here is that you knew that there was a debt that your mom took out in your name for this vehicle. That's the first thing you told me.
Well, I didn't know that she didn't take care of the debt.
Doesn't matter. You allowed her to take out a debt in your name. You didn't report it as fraud.
I didn't allow her. She had a power of attorney when I went to the Army.
The power of attorney doesn't mean I can go get a car in your name while you're serving the country.
That's not true. That's very true.
Yeah, and that no, it doesn't mean that you can go and get a car in someone's name and because they're off serving the country.
She had a power of attorney. It was a financial power of attorney. She could do whatever she wanted with my bank accounts, all my things.
You can't just go and sign someone's name on a car note because you got power of attorney while they're serving the country. No, you cannot.
Well, that doesn't make sense. Then how would she have been able to do it?
She signed your name. She didn't sign her name as power of attorney. She signed your name on a debt. You were aware that she went out and bought this car. You assume she paid the bill. Maybe you didn't. I don't know, but I believe that you knew more about this debt and this card note that was going to be in your name, and that you knew that there was a debt recovery action that was pursued against you. You're not going to even make me to believe that over the course of 20 years, you had no clue that this was on your credit.
Well, Your Honor, it wasn't on my credit, Your Honor. That's the thing. I didn't have any idea. I bought a brand new house, a new car, several vehicles, all sorts of things.
There was a judgment that was entered.
Your Honor, it was never on my credit. Everything was taken care of on my credit before I had bought the house.
Okay, well, it's way far beyond the time frame that is reasonable for the court to withdraw a judgment. So your motion to withdraw judgment or set the judgment aside is denied. On top of the time frame, I do believe that you had notice or you assumed the risk of the debt. I also believe that you knew about the debt from the beginning. You never reported it as fraud. And so to now come to the court to ask to have the debt removed from your responsibility, I think is inappropriate. So you can meet with Mr. Smith if you all want to further discuss resolution of the debt, but you can do that on your own time. Do you have an order that you could provide the court, Mr. Smith?
We'll submit an order denying the motion for the reasons stated on the record under the 7-day rule, Your Honor.
Thank you. You're all set.
Thank you, Your Honor.
Thank you.
I think I still have Justin Wood, who was a 2:30 or 1:30.
Justin Wood here?
He is.
This case ends with a firm denial. The court refuses to set aside the 2006 judgment, citing delay, credibility issues, and insufficient proof of fraud. But beyond the ruling, this case highlights something bigger: how critical documentation, timely legal action, and consistent testimony are in long-term financial disputes. Even when emotional claims like family identity misuse are raised, courts still depend on records, timelines, and prior conduct. Now, the final question for you is, do you think the court got this right, or should cases like this get more flexibility when fraud is claimed after many years? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.